court has reviewed the PSI multiple times. I've highlighted, I've taken notes. I've read this so that I could have a better understanding of you, Mr. Winquist, a better understanding of the victim and victims here, as well as a better understanding of what happened or what people believe happened that day. Your attorney has stated, and the state has as well, the factors, the things that the court has to focus on when it comes to sentencing. Number one is the nature and the gravity of the offense. How serious is the case? Is this matter? I have to look at your character, your prior criminal record, any rehabilitative needs or other things with you. I also have to look at the need to protect the public. And here it's twofold. It's the victims as the public, as well as the general public, because I believe everybody can state that this is true, that alcohol and firearms is very serious, and it's a threat not only to the people in the near vicinity, but it could also pose a threat to people in the general public. That's why we have separate, firing a firearm while intoxicated and other crimes related. It's serious. The court also has to look at the effect on the victims. Again, your rehabilitative needs, any undesirable behavior patterns from you, your culpability, your age, your education, the history. And as Mr. Schmidt pointed on, as well as your attorney did, deterrence. There's two types of deterrence: general deterrence, to generally deter others from thinking about doing something similar. And there's specific deterrence, deterring you specifically from committing this crime and other crimes. I have heard and considered the arguments from both attorneys. I have heard your statement. I have read, again, the information contained in this pre-sentence investigation report. I have heard multiple victim impact statements. And it's a lot for the court to digest. You have admitted here to these very serious crimes through a plea agreement with the state. Count 1 was amended down from attempted first-degree intentional homicide, domestic abuse. It was amended to a second-degree reckless causing injury with a domestic abuse enhancer, as well as use of a dangerous weapon enhancer or modifier. You pled guilty to that offense, and you have pled guilty to 5 other very serious offenses of possession of a firearm by a convicted felon. When the court first tallied what prison time was originally hanging over your head, I arrived at approximately 130 years if the court did a maximum possible penalty. Because if you were to have been convicted of the original charge of attempted first-degree intentional homicide, domestic abuse, upon conviction, you may be sentenced to a term of imprisonment not to exceed 60 years. And then that was amended down to the second-degree reckless injury with the domestic abuse enhancer and the dangerous use of a dangerous weapon modifier, where the maximum possible penalty could be the initial 12.5 for the second-degree reckless with the ability to increase an additional 5 years of initial confinement because of the use of the dangerous weapon and that modifier. All in all, due to the agreement that you've reached with the state, the plea agreement, you essentially avoided a life sentence if you were convicted on all of the original charges. Ms. Fickbaum does not have the same ability to avoid that life sentence. She will continue to live with this day in and day out, not only the emotional turmoil and effects, but the physical effects that she has and will continue to suffer from, which then leads to financial effects and other mental health effects and other things that will seep and continue to seep into her life for her life. And as she stated, you may not have killed her, but her life left her that day. And another thing that she has stated in the PSI is that now she is a shell of her life. She has no home, no car, no money. She cannot live by herself because she cannot manage bills. She forgets things. She falls. She has fear and anxiety. It is a life sentence for her. The primary dispute here today is not whether or not the court sentences you to prison. Both sides agree that this is a prison sentence. It would unduly depreciate the seriousness of the incident and the offense that has occurred. But here the court has to look at all of those factors and all of those things to determine what is an appropriate sentence in this case. Because the court must order confinement at the minimum amount, which is consistent to protect the public based upon the gravity of the offense and your rehabilitative needs. There's not a formula that does that. I can't type it into an equation and have it shoot out an idea of what is an appropriate sentence. And I know the Department of Corrections has something with their compass, some ability to do that. They don't just pull their numbers out of the air. And I know Mr. Schmidt made a comment as it related to your compass. I don't rely heavily upon the compass scores, and I'm not sure how thoroughly your attorney went over that with you of what that means or what that is, but I don't rely heavily on the compass rating or the score. I don't necessarily think it's evidence-based. I don't think that it gives a real idea of the defendant and their ability or lack of ability to stay crime-free. Here, your compass score showed a low risk, that you would be a low risk to commit more crime and violent crime. And that's coming from an incident where you had a gun, a shotgun, and you shot your girlfriend in the head. So that's where the compass really doesn't come into play, or I can't rely upon it heavily, especially because the compass in other serious crimes such as child sexual assaults or offenders or child pornography cases, those individuals also generally show a low risk. So I can't gauge based upon that. What I have to gauge upon and what I have to look closely on is your history, whether this is an aggravated incident, an offense, if there's aggravating factors. I have to look at your ability to rehabilitate, your ability to understand the seriousness of your actions, and not just your action in this incident. We all know that this is extremely serious. There are allegations of domestic abuse between you and the victim and you and your ex-wife. I don't have anything that confirms that. I don't have that you have a criminal history as it relates to that. I don't even have a criminal history of violence with you. It's all alcohol related for the most part, except for perhaps your 2018 conviction for obstructing an officer. But if I look at the underlying facts, I'm going to guess it probably had alcohol relation. And you're nodding your head up and down, so that tells me it did. You have an alcohol problem. You are an alcoholic. You cannot, you should not in any way, shape, or form ever touch a drop of alcohol. And I have to go to a statement made by your counsel as it relates to your operating while intoxicated fourth offense, fourth conviction, which is a felony. It was stated that that OWI fourth conviction changed your life. I don't see it changed your life at all. Not one bit. You continued to drink alcohol while you were on probation. You continued to engage in other activity that you were prohibited from while on probation. The only thing your OWI 4 conviction changed your life in was it took away your right, your privilege, actually, your privilege to be able to operate a motor vehicle and have a driver's license, because it took it away for life. But I'm going to tell you, I don't believe for 1 minute that you didn't drive illegally after your OWI 4th conviction. Perhaps you didn't on this day, as your attorney said, because he said this changed your life because you were no longer able to drive, and it appears he wasn't driving the day of the incident. That's the only thing that it perhaps changed your life. Maybe you didn't drive that day, or we have no facts that suggest that you drove that day. But the fact that you couldn't abide by your probation conditions, the fact that you continued to drink alcohol after your OWI 4th conviction while you were on probation, the fact that you continued to possess firearms when you are a convicted felon, leads me to believe that you wouldn't follow the lifetime restriction of no driving or having a driver's license either. So I don't think your OWI 4 conviction changed your life. If it had, perhaps we wouldn't even be here today. I do know that that day did change the victim's life. It changed her son's life. It changed her entire family's life. She now feels like she is a burden. She's not the same person she was previously. she feels she never will be. And I know that it was brought up in the PSI and was brought up in arguments here today that, and from the victim herself, that you were shot with a rifle during an incident. I remember that day, not that day, but I remember that incident very clearly because that impacted your OWI third conviction in front of me. That incident occurred when you were at a bar. You were standing up outside or something like that. The individual was cleaning his rifle in a house across the street. There was a cord on the floor. He was walking with the rifle. Somehow the safety wasn't on and it was loaded. Those are no-nos. But he tripped and fell. The gun shot through his glass sliding door, shattered the door, went across the street, went to the area on the bar's property where you were and struck you in the buttocks. Accident. It was an accident. This incident was on purpose. It wasn't an accident that you picked up a shotgun, you pointed it at your girlfriend at the time, you pulled the trigger, and you shot her in the head. That wasn't an accident. No matter how many people don't remember what happened or the incidents that occurred that day, or what was going through your mind, that was not an accident. Yours was an accident. Your PTSD, if you have it, and that's been said that it could be from that, or could be from this or that or the other. Any trauma that you have suffered from your shot in the buttocks, completely, 100%, totally different than the trauma that the victim here suffers from. Because she had somebody who said, I love you. She had somebody who said, from the words of your counsel, you thought you were married. You wore a wedding ring and you pledged yourself to her life, to her betterment, to make her a better person and to have this life. And you picked up that weapon that you had no legal right to possess, and you shot her in the head. It was not a heat of the moment type of incident. We don't have anything that from the juvenile who was there, who heard fighting all day, who heard a huge fight, and then all of a sudden a shot. He was downstairs in the basement playing a video game. He didn't hear that. You have had alcohol issues since you were 12. I know that it's been stated that that's when you started using alcohol, and it didn't get bad until you were 15, and you didn't have a problem until 15. But I'm going to tell you, starting drinking alcohol at the age of 12 is bad. It shows an issue. And again, you nodded your head up and down. It is. That was the start of your downfall. And whether or not your consumption of alcohol decreased while in the Marines, which again is kind of hard to believe because of the stories I've heard of people in service. Even if it did, once you returned and you were honorably discharged from the Marines and you came back, that's when it started again, not from the date of when you got shot in the buttocks. Because again, I remember that because as I took your OWI third conviction and I was being lenient to you in that conviction and was going to allow you to not have to sit in the jail for the 48 consecutive hours by law you're required to do, to serve that on an electronic monitor because of your injury, I took your conviction, you went up to jail to be processed, and you blew a 0.2 something. You were beyond legally drunk when I took your OWI third conviction. So I had to redo that conviction to ensure that you remained sober. And no, I did not allow you to get out on monitor. That's where I found an error in the PSI. You had to sit in jail. I did not allow you to be released on monitor because that was serious as well. So your alcohol issue is what has gotten you here in part, because both sides have argued and stated that you ignored your issues. You ignored the things that were going on in your life and with you. You ignored your alcohol issue. You ignored the PTSD that you felt. You ignored the violent nightmares that caused you to have outbursts. You ignored all of these things. And it put others at risk. And again, I want to stress, it didn't only put the victim and her family and son at risk. It essentially could have, serious harm could have occurred to the public in general because of this. Alcohol and guns do not mix. The fact that you were convicted of an OWI fourth offense of felony, you were told you were still on probation. You were told that you could not use or possess any firearms. That meant it's not all on Miss Fickbaum's shoulders because it was her house. You live there too. And as you said, you felt she was your wife. It's not all on her shoulders. You as the felon, you on probation, you are the one who knew that any weapons in that home needed to be under lock and key, or they could not be in that home. And you were not able to have access to that key. It's not all on Miss Fickbaum's shoulders because that was her home. You are the one who knew exactly that you could not use or possess firearms. Yet you did. And the argument or the statement made was you had the shotgun to use for self-defense. That is not an excuse. That is not a reason to have an exception for a prohibition to firearms. There would be if your life at that moment, you needed that weapon for self-protection because it was imminent and you were in a life-threatening situation. You were not. And as applied to you with an OWI fourth conviction, still on probation, extreme alcohol misuse and alcohol disorder, you had no judgment or no judgment to even be around firearms. Alcohol and firearms are dangerous and can be very violent. So as applied to you, that prohibition is necessary. And then you add all in your personal issues, the violence, the aggressiveness, the PTSD, those nightmares. On top of that, especially as applied to you, the prohibition is necessary. I do have to look at your rehabilitative needs and to see if you have the ability to rehabilitate, if you want to rehabilitate, if you want to change your life. Because this, as it's been stated or argued, that this has impacted your life as well. It's kind of like a shot again to the victim, that it's impacted your life. Your freedom may be restricted. You may be incarcerated for a significant period of time, but one day you will be released, even if it is on extended supervision, and you won't be suffering from the lifetime effects that the victim is. Not to mention her son. The trauma of having to hear the thud, knowing the thud when he came up was his mother, knowing she was shot in the head, not knowing if she was going to live, having the fear that you could have, in whatever state you were in that day, knowing, not knowing, shot him and killed him. How you've devastated his life and his relationship with his mother. She's not able to do activities or do things as much as she was before. He now feels like he has to protect her. He now feels like he has to be the one to care for her. He's a child. He is a child who does not deserve to have to worry about these things. And now he does for the rest of his life. I want to make sure that I have covered everything that I have highlighted. As I'm looking, I do want to point out that it's a miracle. And thankfully to all that believe in higher powers, it is a miracle that Ms. Fickbaum is alive. What she suffers from daily is worse than death. I'm not going to even expand upon the statements made about the other domestic violence with your ex-wife, or the things that I think are abuse, emotional abuse, and other things with your children, and the fact that you had them eat under a timer, because I don't have any real concrete information that either of that has occurred. Because you do state, and you have stated to the DOC agent, that you were never physically abusive to Ms. Fickbaum. You were never abusive. You were not a violent or abusive person. The PSI says that there is a lack of remorse, and I know that Ms. Fickbaum has stated that that is something that she has been missing as well, seeing a lack of remorse. Your attorney has stated that he has directed you not to speak about that. You did provide that here today in a statement saying that you are sorry for those actions and what happened. that shows some remorse. I'm not sure how much, but that shows some remorse. Now, in factoring everything together and looking at the totality of the circumstances here, and especially looking at the gravity of the offense and not wanting to unduly depreciate that gravity, and to find a term of incarceration to meet the court's objectives, the court believes that a sentence that would not unduly depreciate the gravity of the offense to fit the crime and the crimes that have occurred. And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident, and it aggravates what happened that day. And although Ms. Fickbaum may have engaged in alcohol consumption that day, and she may have been extremely intoxicated as well, she in no way played a factor in you taking that weapon, you taking that gun and shooting her in the head. None of that, none of it is her fault. None of it. With regards to count one, the second-degree reckless injury with the domestic abuse enhancer and the modifier of use of a dangerous weapon, the court is going to sentence you to 17 and a half years of initial confinement. That would be the 12 and a half years for the underlying second-degree reckless injury, plus the max for the use of a dangerous weapon modifier of 5 years. The court finds this to be so egregious, so serious, that the maximum possible penalty is necessary not only to protect Ms. Fickbaum, but to protect the public in general, because I have not seen that you have a desire to follow the rules and to follow the law in any way, shape, or form.
Judge, I'm interrupting. I do that at risk. You said 17 and a half years confinement. I think the maximum is 17 and a half years imprisonment, 12 and a half confinement, 5 and
12 and a half okay, I read that on Mr. Schmidt's argument. So 12 and a half years, well, Mr. Schmidt, because it says the maximum not more than 12 and a half years. Oh, 7 and a half is the maximum. Sorry. I apologize for that. So with count one, the court is going to sentence you for the underlying second-degree reckless injury, 7 and a half years of initial confinement. And then the maximum for the use of the dangerous weapon, totaling 12 and a half years of initial confinement with 5 years of extended supervision. As it relates to count two, possession of a firearm, convicted felon, the court also finds this egregious. The fact that he knew he was a convicted felon, as applied to him, it was very serious. He was simply just on probation not too long before that. The court finds that a maximum of 5 years of initial confinement and 5 years of extended supervision is necessary. Counts 1 and 2 are consecutive to each other. as to count 3, possession of a firearm by a convicted felon. The court finds that that is still serious and egregious. No matter where the firearms were placed, he knew of the prohibition. He knew that that was for life. He was still on probation. He was on a no alcoholic drink prohibition. He was extremely intoxicated. The court is going to sentence him to 3 years of initial confinement with 3 years of extended supervision. That is consecutive to counts 1 and 2. As to count 6, possession of a firearm by a convicted felon, the court finds the same. 3 years of initial confinement with 3 years of extended supervision. That is going to be consecutive to counts 1 and 2. And concurrent with count 3. For count 7, possession of a firearm by a convicted felon, the court also finds the same things as to counts 3 and 6. 3 years of initial confinement, 3 years of extended supervision. That is consecutive to counts 3 and 6, consecutive to counts 1 and 2.
Judge, did you say consecutive or concurrent? 7 is concurrent with 6 or consecutive?
Consecutive. It's consecutive to all counts. Count 8, possession of a firearm by a convicted felon. Same basis. 3 years of initial confinement, 3 years of extended supervision. 8 is concurrent with count 7, but consecutive to counts 3 and 6, and consecutive to counts 1 and 2. In my calculation, it's 26.5 years of initial confinement. And I believe 16 years of extended supervision. The court finds this to be so egregious, so serious, and so preventable. Had Mr. Winquist recognized his problems and did something about it, he did not. He failed to do anything, and he had sign after sign after sign, and he failed to even recognize or address them. And he continued to violate the law. He continued while on probation to violate the law and violate his conditions of probation multiple ways. An extended supervision when he is not eligible for early release programming, either the challenge incarceration program or the substance abuse program. until the last 3 years of his sentence, if any. On extended supervision, absolutely no alcohol, no illegal substances, no paraphernalia, no prescriptions without a valid prescription, gainful or some type of employment to occupy his time and his mind. It does not have to be full-time. It can work with his disabilities. Absolutely no contact with Christina Fickbaum or any of her family members, any residents, any employment that she may have or her family members may have. The court is also going to order that he has an AODA assessment and follow-through treatment. He engages in some type of criminal thinking, such as thinking for a change or breaking barriers. The court is ordering $12,582.23 in restitution. The court is going to order $518 in court costs and fees per count, except for count 1 has an additional $100 due to the domestic abuse surcharge. These are felonies. Absolutely no use or possession of firearms for life. No voting in any election until your civil rights are restored. Court is ordering his DNA. This is not something he can have expunged due to the seriousness of the crime. Failing to pay his fines and fees, a civil judgment will be entered. If he is released on extended supervision and has not paid his fines and fees, a warrant will be issued. He can sit up to an additional 6 months in jail. Restitution is paid, so the court is going to order at minimum a monthly payment of $150 per month until paid off in full. The court ordered court costs, surcharges, and fines are to be collected as a percentage as determined by the Department of Corrections to be reasonable while he is in a state prison, and as a condition of extended supervision, he is ordered to pay those upon release. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe I've covered everything, Mr. Schmidt.
Just to clarify, I think I wrote down wrong about 3, 6, 7, and 8. The court ordered 3 and 3 out on all of them. They're all consecutive to counts 1 and 2. 3 of them are consecutive to each other. 1 of them is concurrent to that group, totaling 26 and a half and 19 out.
19 out? You could have added the ES correctly. I didn't write down the ES. I was trying to do it by my head.
Okay.
So,
Did I state the rest correctly?
correct.
Okay.
Anything else that is missing, Mr. Schmidt?
That wasn't missing. I think I just heard wrong.
Mr. Harrington?
No.
All right, then we are adjourned.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.